Hello everyone, and welcome to this HEC Paris virtual conference room for our HEC Insights webinar series. When joining the conference, you will notice that your microphones have been switched off. You will, however, be able to ask questions and make comments using the Q&A menu that you will find at the bottom of the window in the Zoom toolbar. The professor will only answer questions and read comments sent through the Q&A menu and will not be taking any questions coming from the chat. Please be aware that questions in the Q&A can be upvoted by clicking on the thumbs up icon and thus prioritized on the professor's dashboard. Make sure that you keep the chat for technical questions to our team only. We'd also like to remind you that the webinar is broadcasted live on YouTube. We'll now begin, and I'll leave the floor to Anne Michaud, Dean of Pedagogy at HEC, for the beginning. Anne?
Thank you, Adrien. Thank you very much, ladies and gentlemen. A warm welcome and thank you very much for being with us today. I am Anne Michaud, Associate Dean for Pedagogy at HEC Paris. And it is my greatest pleasure to welcome my colleague Matteo Winkler, Associate Professor at the Tax and Law Department of HEC Paris today. Matteo's research spanned from cross-border business transactions, human rights, transnational litigation, commercial arbitration, and diversity management in corporate settings. Today, Matteo will talk about inclusiveness beyond compliance, the topic of his current research. Thank you, Matteo, for accepting the invitation to speak in this webinar. A warm welcome to you, and the floor is yours.
Thank you very much, Anne. I guess you hear me well and you can see me. So thanks a lot for organizing this webinar. Thank you to all the people who worked to make it happen properly. So let's start with a very quick outline of the argument that I'm going to present in this webinar. So my argument is that when we talk about compliance with anti-discrimination law, we can see from empirical research and theoretical reflections that have been ongoing since the last few years that anti-discrimination law compliance does not ensure full inclusiveness. So if we want to have a fully inclusive workplace, we need to look beyond anti-discrimination laws. And in fact, we need to change mindset. So the current mindset in corporations is that anti-discrimination laws must be applied strictly, and that you are consistent with these anti-discrimination laws simply if you don't discriminate. But I propose a new mindset for corporations for managing a more inclusive workplace that looks beyond anti-discrimination laws to ensure full inclusiveness. This said, a very quick outline of my presentation. First, I will describe more in depth my argument. So whether anti-discrimination laws ensure full inclusiveness or not. Second, I will propose two case studies. The fact that these case studies come from Italy, both of them, is just a chance because for sake of my argument, I had to choose two cases that are very distinct but have some analogies. And these two cases coming from Italy were very well, fitted very well this argument. So my apologies, there are not so much diversity in my case studies, but you will see why this was important to, why these two cases were important. Third, I will analyze and identify the limits of anti-discrimination laws by moving from these two case studies to a more theoretical part. And finally, I will propose three very simple recommendations to move away from strict compliance with anti-discrimination laws and ensure a more inclusive workplace. So Adrienne Penturier, who is assisting me, if you can please launch the survey. There is a very quick survey for you to complete. The question is, how many discrimination criteria are prohibited under EU law? So it means how many grounds of discrimination are not permitted in EU law in general, not necessarily in the workplace. So the answers are 3, 15, 24, or 8. Please vote.
Matteo, as we've reached 80% participation, I suggest we end the polling.
Yes.
And we'll share the result.
Very good. So 10% have said 3, 35% said 15, 31% said 24, and 25% said 8. So I will see that the majority gave the right answer, because the right answer is 15. So thanks for participating. We have, in fact, 15 criteria on which discrimination is prohibited in EU law. Not all of these criteria apply in the workplace, but most of them do. So basically we have sex, race, color, ethnic and social origin, genetic features, language, religion or belief, political or any other opinion, membership of a national minority, property, birth, disability, age, and sexual orientation. You may find yourself in some of these categories. And of course, we all have a sexual orientation, we all have a sex, we all have a race. But the thing is that these are criteria on which states cannot discriminate in the European Union. In the European Union, moreover, there exists a framework of anti-discrimination law which prohibits discrimination based on certain criteria like gender, sexual orientation, age, disability, and religion. But let's move a little bit back in history. In this picture, you see Jane Elliott, a third grade teacher in Riceville, Iowa, a very a small town in the Midwest. And she's teaching to her pupils, her kids, who are 8 to 9 years old. In 1968, which is the year when this picture was taken, she proposed an experiment with her kids, which became very famous in the world and raised a lot of controversy. Basically, initially in the US, but then all over the world. So she divided the class in 2 groups. So first of all, the context is that of the killing of Martin Luther King, which happened on April 4th, 1968. So after that night, the day, one day later, on April 5th, she engaged herself in this experiment. So she divided the class in two groups, and she put a collar, a band on the arm of each child to recognize them. And she said that some of them, half of them, were brown-eyed, and half of them were blue-eyed. She chose high color because she believed that distinctions based on race were based on the pigments of the skin, which extended, of course, to our eyes. So she observed then what happened. She divided the class in two, brown-eyed and blue-eyed, and she moved the brown-eyed in the front rows, leaving the blue-eyed in the bottom of the classroom, in the back. Then she structured the entire day, giving a lot of power to brown-eyed kids. So giving them priority to go to break, precedence to be served breakfast and lunch, and so they were prized, they received more little gifts, while the blue-eyed received nothing. And what she observed was stunning. She saw that the brown eyes started treating the blue eyes eventually exactly as dominant class usually does with dominated classes. So they subjected them to humiliation, they played with their behaviors, they judged them very quickly to say that they were not capable of doing anything. And at the same time, the blue-eyed behave in a way that diminished their self-esteem. She observed also another phenomenon, that blue-eyed kids stopped learning. So there were dyslexic, for example, kids in her classes, and when these dyslexic kids were appointed as brown-eyed, they stopped their dyslexia and they started reading properly. Those who were failing in math, they now were able to get calculations perfect. On the other hand, kids now pertaining to the blue-eyed category, they stopped learning and they stopped doing math properly, and they started suffering dyslexia. So her point was very much that you can simulate very quickly a situation of power in a classroom which reflects racism and creeping racist behaviors and stereotyping and bias that affect societies in general, and while at the same time impacting the learning environment in the school. The day after, she reversed the experiment and she moved with the blue-eyed kids being the brown-eyed. And she observed the very same behavior that she observed the day before. So the problem of this experiment tells you about who comes first, prejudice or discrimination. So we normally believe that we discriminate because there are prejudice. But her point, which was much deeper than that, and she said that basically it's discrimination that causes prejudice. So because people are discriminated in society, society creates prejudice against these vulnerable groups. And this result is very, reflective of my argument, because I'm wondering whether anti-discrimination laws, as they are applied, can work to fight prejudice properly. That is the real question I'm trying to answer now. So when we talk about anti-discrimination law, basically we deal with four main things. So when we think we have been discriminated, we need to see whether anti-discrimination law applies to our cases, and at the same time the employer will do a mirroring reasoning on the same direction, right? So the first thing you have to ask is whether anti-discrimination law applies in the workplace. We have sectorial regulations that apply in the workplace, but anti-discrimination laws apply also in other contexts, as you know, the battle for same-sex marriage or for transgender people teaches us from the United States. There are different layers of regulations that apply when we feel discriminated. Feeling discriminated in marriage or in adoption right is not the same as being in the workplace. In the workplace, there are very sectorial, very specific regulations. The second thing is that we have to understand that discrimination is not a sole concept. It's not a notion that encompasses. It's a notion that encompasses many different behaviors. When we talk about discrimination, for example, we talk about direct discrimination and indirect discrimination. Direct discrimination is when we treat someone less favorably than another person based on a characteristic over which they have no control. So basically, it's one of the characteristics that we saw before, right? So sex, gender, sexual orientation, religion, age, and so on. On the other hand, we have indirect discrimination, which is harder to show because indirect discrimination happens when you have apparently neutral measures that in fact create a disparate advantage to some people vis-a-vis other categories, right? So for example, if I imagine that a company will enact benefits for part-time workers, we can usually see that this will impact women, female employees more than men, right? Because statistically speaking, women tend to ask for part-time more frequently than men. And this, of course, creates an impact, even if the measure per se is conceived very in good faith as being very neutral, applying to everyone. So if the fact that it applies to everyone, it doesn't mean that it's not discriminatory. This indirect discrimination is very hard to prove because you need statistics. Right? You need numbers. And when you talk numbers, you go to court, I can tell you that courts need help to interpret those numbers. So another point which deserves to be mentioned is that there are exceptions to these anti-discrimination laws. One of these exceptions pertains to religious freedom. And of course, there is a huge debate, for example, in employment authorities in the US, whether as a subsequent to Supreme Court's decision of last term, where you can discriminate in certain cases based on religious beliefs, right? And this is a very sensitive issue nowadays. Another thing you have to see is whether the victim can sue or whether someone else can sue on behalf of the victim. Sometimes the victim does not want to show up, and therefore there are associations that replace the victim in suing in court. Finally, we need to see whether victims are protected if they come out with a complaint, because of course we need to avoid retaliations which impact a victim's career and will of course silence any claim concerning discrimination. So, well, discrimination won't work. Anti-discrimination laws won't work if people don't sue, basically. And finally, and the very last point is how much compensation would a victim of discrimination obtain? I want to, let's start now with the two case studies. This picture that is, you can see it's horrible, but this person took it and published on Instagram a public profile. So I think it depicts perfectly the style of this person. So this person is a law professor and an attorney at law, very famous in Italy because he has been also a member of the parliament for some time. And he was participating in a radio broadcast where he was, which is called La Zanzara, which is very, how can I say, humoristic, but also sarcastic and very touchy when it comes to big issues like discrimination or gays and so on. So the guy was asked whether what he would do if he was introduced to a candidate to work in his law firm, and who happened to be the best lawyer in the world, but who also happened to be gay. And he responded that if he's so good, why doesn't he look for another law firm or create his own law firm? I don't want people like him here because this will create difficulties, because having an homosexual in a law firm will make the environment toxic. This is his opinion. And of course, gays made him sick. So here we have a case of the owner, very influential owner of a law firm, saying that he will never hire a person. The question is this a workplace? Is this discrimination? Where is the victim of this discrimination? He's just speaking in a radio broadcast. He never had an actual candidate in front of him. He never kicked out anyone from a job interview. So where is the discrimination here? The second case pertains to Mr. Guido Barilla. You know, Barilla is a famous pasta manufacturer. And so he was interviewed always in the same radio program, of course. And he was asked what he thought about non-traditional families, like families composed by same-sex couples with or without children. And he said that he is a big fan of the sacred family, and therefore if people who are homosexual or they don't like traditional families, they don't belong to traditional families, should buy another pasta, which LGBT consumers actually did. And so if one day after this interview was released and published, he had to apologize. And he said basically that he was ignorant, that he didn't know anything about same-sex couples and LGBT people and families. And therefore, Barilla now is one of the most active companies in terms of diversity and inclusiveness. So we need to ask again the same question here. Who are the victims of this discrimination? It didn't seem to discriminate against people in the workplace, because it just said consumers should go to another place, as simple as that, and to buy another kind of pasta. So the question is there a discrimination here? And above all, is anti-discrimination law enforceable in this case? So we have two different cases. People in power, male, very important, powerful people, saying statement or utterances which can create an atmosphere within their workplace indirectly in both cases. But my question is, can anti-discrimination law fight, prevent, and change behaviors people, like, for example, Carlota Ormina's and Guido Barilla's statements? And the answer to this question is not easy, because we have many problems that affect anti-discrimination laws, which are very much reflected in these two cases. So first, are we in the realm of workplace discrimination, or should we, for example, look at other sectors, other layers of law, such as, for example, hate speech legislation? The second point is a standard of proof fulfilled? Remember that anti-discrimination law requires a certain standard of proof, which is on the respondent, but the plaintiff, the claimant, has to show in first time, in prima facie, that the discrimination has been committed. Is there a discrimination here? There is not even a candidate for a job or an employee So it's difficult to see whether this standard has been respected or not. Finally, who is the victim and which kind of compensation can we ask to these people if we decide to sue? In Barilla's case, the difference is much more relevant because the people who are the victim of these utterances are not the Barilla's employees, even if, indirectly, gay people who work for Barilla can feel offended by what their boss, their CEO said. So let's move a little bit further from anti-discrimination law and look at the so-called microaggression theory. So the microaggression theory was elaborated since like the 2000s, and it moved on in 2010 and later with more research. So basically, microaggression theory says that we are all subject to microaggressions in everyday life. Microaggressions consist of micro-insults when we show lack of respect towards a certain group. Micro-assaults when basically we say discriminatory statements to show disapproval of a specific person or a specific group, which is the case of both Taormina and Barilla. And now, then we have micro-invalidations by which we nullify the experience of being a woman. So, for example, when Sheryl Sandberg's book Lean In showed, is a very famous book about women's gender balance in the workplace. She said that statistics show that women tend not to object when there is a board meeting or a team meeting, and they are afraid of making their opinion out. So this environment can be characterized by micro-invalidations, which means that saying that women's experience or words are not interesting to be told or interesting to be heard. A phenomenon that we see very clearly in some workplaces is when we sideline the experience of gay people, for example, by silencing their voices, or by saying that someone's inputs are not interesting or are not relevant for decision making, or even under recognizing skills that some people have. For example, there is this stunning story of Lord John Brown, who was the CEO of British Petroleum until a few years ago, and he was gay, and he never came out because he was afraid. And then at the end, he had to resign because he was involved in a scandal concerning a male, very young male friend that he had for some time, and that blackmailed him and went to the newspapers to tell the story. So he had to resign not to put his company in jeopardy. But the entire point, he tells his experience in the social media, and he said that actually being gay is not an obstacle to become CEO in BP, but he was afraid because he couldn't identify how the reaction of people would have been if he came out. So at the end, this destroyed his career. And obviously the environment contributed to that by sidelining the experience of powerful people who also belong to minorities and vulnerable groups. So to conclude, we can see that there are different topics that we touched today, and that are, let's say, reasons for reflection for further discussion today, for your your own reflections on this topic. So first thing is that, should we really litigate anti-discrimination laws, or wouldn't it be better if we cultivate a culture that prevents these lawsuits from happening, not just looking at how anti-discrimination law is enforced and complied with, but also looking at how the environment can by itself develop a culture where microaggressions in everyday lives are reduced to the minimum, to mitigate very much microaggressions in everyday lives. The second point is that, which is shown very much by Barilla, is that the statement of one person might not be triggering litigation, but if we collectively and holistically develop a conversation about diversity and inclusiveness, which has nothing to do with anti-discrimination law, but goes to see how people behave in the workplace, regardless of possible litigation, we can win, everybody wins, because we feel more included. And actually, you know, when I say to my students, what is inclusiveness? Inclusiveness is developing a sense of belonging, after all, and using diversity to gain more in your own lives, more in terms of performance, but that's, as I will say shortly, performance is not the only indicator of inclusiveness. Also, I want to quote cite a case, BNP Paribas, which was a case that was decided by the Court of Appeals of Paris in 2016, where a person, an employee, a former employee, was awarded 300,000 euros of compensation because he received naughty emails from colleagues showing that he was gay. And these emails were very diminishing and humiliating, and basically the court said that the company didn't do enough to prevent this from happening. By 2016, when the lawsuit was already ongoing, the company had just enforced a lot of measures against discrimination and favoring inclusiveness, including a very active employee resource groups in both gender and sexual orientation fields. Also, a fourth point is a very big question for which maybe there is not a very clear answer, but it's a conversation we need to have, is whether anti-discrimination laws really empower employees from vulnerable groups, and whether we need to go beyond anti-discrimination law, which was my point, to empower, to develop a sense of belonging, which helps because we work we spend 2/3 of our lives in a workplace. It makes sense that we develop a culture which makes everyone belonging, like being at home, right? One thing that I want to add about last point, BNP Paribas, that I cited, is that even if the litigation was ultimately triggering some measures, the point was that discrimination law, even if it doesn't work perfectly as it should, it actually makes discrimination visible. For example, 2 years ago, there was a case in the Court of Arbitration of the ICC in Paris, where one of the parties challenged an arbitrator because this arbitrator was 76 years old, and they argued that by the case was over, he would have been, like 81 or 82, so too old, they claim, to make sense of the case, right? To judge a case of international business transactions. And the response of the court is interesting because the court rejected the challenge, but at the same time said, this is a clear conversation about discrimination that we need to have. And since then, a lot of discussion is going on about whether we should have more younger lawyers in the arbitration field, younger arbitrators. So an intergenerational conversation, okay? So finally, I propose 3 recommendations to both employee and employers to make a workplace more inclusive. The first is to adopt a holistic approach to inclusiveness, which means to look beyond possible single cases of discrimination, which will be dealt by the legal office ultimately, but every manager should look at how inclusive his or her teams are and how they can take advantage of the diversity that exists in these teams. Second, training is insufficient. You need actually more. So when you say what we do, when you ask yourself what do we do as employers for making a more inclusive workplace, the first answer is we do trainings. We take a bunch of employees, we put them in a room for one afternoon, we ask an expert, which could be Professor Winkler, of course, but an expert in D&I, in diversity and inclusiveness, and they talk about bias, prejudice, and they help people, to move on with their feeling of not being included enough and so on. Well, research shows that training doesn't work for many reasons. The main reason is that if you take Daniel Kahneman's Thinking Fast and Slow book, you will see that he divides the brain in two systems, system 1 and system 2. System 1 is the one that runs automatically, like when we are driving from home to the office, and system 2 is the rational mind that helps us with difficult arguments and mathematical calculations. Training is insufficient because we try to have a rational conversation, while most of the microaggressions in our everyday lives happen because we activate system 1, and system 1, which is the automatic one, which is full of bias and stereotypes, works normally, is the system that we use most to take our decisions. So targeting only the rational mind doesn't make any sense. We need to work more on subtle messages and designing inclusiveness in our workplace to make things work. So gathering people in a room as if they were students and telling them how beautiful it is to be inclusive doesn't make any sense and really does not cause any change, because when we talk about inclusiveness, we need to reflect about changing behaviors. Inclusiveness does not make sense as it is. Inclusiveness makes sense if we get value from it, and which is not necessarily money, is not necessarily profit, right? Which comes to my third point. Do not focus on the business case only. I'm also a member of an organization called Open for Business. They do just the business case, which is perfectly fine. So they look at statistics and they tell us that, for example, being inclusive with the LGBT population will increase the GDP or will increase a company's profits and the company's performance because people will work more. And I've heard that in some trainings that people told me, if you are gay and you come out and everyone is fine with that, you work 25% more. So my point is that I don't care about working 25% more if this makes me richer and not just the company, right? So inclusiveness must be considered as something that everyone takes advantage from. So on this final note, I think my time is over. I hope I respected the time that was assigned to me. And let's open the discussion for the Q&A. Thank you very much.
Thank you very much, Matteo. Thank you for these very interesting topics that you brought up. I think we all encountered some of these examples, although maybe not as clear as the ones you presented. I will start with one question that was maybe related to the current situation, and it's on discrimination indeed. And it says that at times it may appear desirable to discriminate, potentially to protect vulnerable groups. And the example that was given is, of course, a virus like COVID-19 does discriminate, for instance, on age, but governments cannot discriminate as an answer on H because of the examples that you presented, the laws that you presented at first. So is it sometimes a limitation, those anti-discrimination laws? And what can companies find to go around it for a good purpose when there is one?
So yeah, so there are many things. I mean, we can have another seminar, another webinar on the effects of containment measures and COVID-19 on vulnerable groups. I'm actually conducting a research with my colleague David Restrepo from the law department at HEC regarding how restrictions caused by COVID, governmental restrictions in particular, have affected vulnerable groups. You mentioned an age, but it's not only that. I don't know if you remember when we all went to the first lockdown, which was kind of unknown moment where, sorry, not unknown moment, but like it was a moment where everything was unknown about this virus and how it was transmitted. So the government, the French government, I speak for France, but I can say Italy, Spain, any other country in Europe, they decided to go to a total lockdown and to prevent the virus from spreading. And at that time, there was an injunction that was extended to everyone, like stay at home. The problem is that this injunction makes totally sense given the circumstances, right? But if you look at it as, you know, in the possible discriminatory consequences that it has, what about the homeless? Who will take care of the homeless while everyone stays at home? Who takes care of prison mates while everyone stays at home? And of course, if you look at the micro universe of families, who take care of the children while you are at home? And then also there are multiple rights that are impacted, like right to education, and so on. So there are many dimensions of discrimination that are triggered by this COVID. I think that one, well, I can give you another very nice example. When you use your apps, anti-COVID apps, for example, you don't, or you tell people that students can have remote classes, right? You don't take into consideration that the digital divide. So you tell people that do not have a smartphone that they should download an app that will help them prevent the pandemic. And how can these people react is not known. So depending on, of course, on the countries in the decision making, it makes sense for regulators to take into account the possible disparate effect of these measures on vulnerable groups. And of course, when we say vulnerable groups, there is also an idea of vulnerability which is defined by susceptibility to the virus. So the more susceptible we are, the more vulnerable we are. And susceptibility is not just a clinical term, a medical term, but it becomes something that pertains to how governments decide to enforce, to implement and enforce anti-COVID measures. So I don't know if this answered the question. I think in this case, you discriminate when you take decisions in the sense that you actually envisage different rules or rules that are made flexible for very specific context. Well, just to finish on this question and take another, when Macron said before the last confinement, universities will go a distance, will go for remote teaching, he didn't consider that there are schools that have like 50,000, there are universities with 50,000 students who are 200 or 300 in the same room, while there are schools that are in the same system of universities that have like 15 to 20 to 25 people in the room. By treating them in the same way, the government created a problem. And by distinguishing them, which is actually discriminating, you can module rules for different contexts, different populations based on their vulnerability, which actually requires an assessment.
Okay, thank you very much, Matteo, for this answer. Very detailed. We have a couple of questions about, okay, I think at some point you said training is not enough. And I think we see that by and large in many organizations. Now, there are two questions that might be related to this. First one that says, okay, mostly we see that people that are discriminated are the first one to be sensitized and educated about discrimination. But the truth is all individuals should be, and then how to. And the second question may be related to this as well, is how to make people responsible for microaggressions better understand the impact of what they do. And Sylvie, who asked this question, said, I guess some of them don't even see what they are doing. And it's true that we see that a lot, and also that the feedback that we get from discriminated people is that unfortunately many times people don't even realize that what they say or do is discriminating.
Right. So starting with the first question, I think we need to have a serious conversation about experiences with discrimination. So, which is the experiences that we have and make ourselves what we are. When I was working in a law firm back in Milan, I was told by a colleague, because there was an important meeting and we had to get the job, of course, that I shouldn't move my hands too much because I looked too gay. So this was a form of microaggression, right? And the point was that I couldn't do anything because the law firm I worked with was part of a federation of law firms in the world, but they had not a centralized LGBT or diversity and inclusiveness office. And of course, everything was given, to the local partners who decided not to react. So the first point is, therefore, my experience with discrimination did not actually stop moving my hands, as you will have probably noticed, but taught me that you can't rely, depending on the context, you can't rely on reaction. So you need to build them, right? And the first thing is to build them is not to be afraid to talk about what happened to you. So I tell this story to everyone, and actually these isolated the colleague who did these statements. So there is a sort of form of social stigmatization which goes against the author of the discrimination, of the microaggression, against the microaggressor, rather than against the victim. So if this happens, you can see that your workplace is more healthy than what you may think. The second question was, sorry, Anne, how do we, what's the responsibility? How do we take responsibilities for microaggressions? So I think there is always, you can always talk to your manager, of course, to make things, very open in the discussion. There are also issues about confidentiality and vulnerability. Vulnerability is not very easy to show in public. But people who use vulnerability to build up stories for themselves to help others, they normally succeed. So, for example, regarding coming back to training, what works with training, again, is personal stories. Do not call for someone who has teaching experience on diversity and inclusion. And I speak against my interest here. But call someone who has interesting and relevant stories to tell. Call a transgender person who has issues with during the transition period, who lost her work because of the transition. Let her talk, or him talk, and tell their story in a way that people, research shows that people don't listen more than 20 minutes of a talk by a professor, but they listen to a story which touches upon their own experience. So if you create a bond, this really changes people's behaviors, because it touches upon system one, which is, the automatic machine that drives our behaviors, and not just building a rational mind. So what I do in my courses, for example, when I teach to HEC students, is to do both. To create an infrastructure where students can learn about feminism, white privilege, colonialism, patriarchy, which is obviously the rational mind, while at the same time doing exercises that bring their experience in the front row and their personal stories. So we have to find the balance between these two things.
Yeah, thank you, Matteo. We have another question, so it's a bit of a lengthy one, so I hope you will stay tuned. It's about targets of inclusions, and targets like 50-50 on gender, or race, and all these different criteria that can have been put forward. And it's a question that says, okay, having these targets is fine, but then in the short run, that means that we are going to discriminate, for sure, other people, for instance. So it's like a balance, and also sometimes having these the willingness to make the switch very fast can backlash on these very people that have been just hired, because in the end they might be the first ones to be fired as well if in the end it doesn't fit. So it's the idea of how do we balance these targets with the idea of making it really short-term targets versus long-term feasibility of this inclusiveness.
Okay. Well, we touch here a very delicate issue, which is that of quotas that are usually reserved to more vulnerable groups, which does not mean that these groups are not statistically dominant. For example, women are actually not 50% of men in the world; they are more, but they they are reserved 50% because we assume that there are only two genders, which is not always true. But I think we need to understand a little bit where anti-discrimination law comes from. Anti-discrimination law was conceived to make minorities, to protect vulnerable groups and minorities. Now they have become something very different, which is troubling me, and I need to reflect more upon that, because I think there is a lot of research to do. One example is 1 week ago, I think, the mairie de Paris, the government, or the town government of Paris, has been fined because they had 67 women in the top leadership positions, and the rule is that you can have only 50. So this fine was like 90 million euro, was like a huge amount. And my point is that where is social justice in this system where you have only 50-50? Because, men were dominant in leadership since 1,000 years, and just in the last 2 centuries, when women started to complain about that, they have been given the possibility to reach top positions, but not more than 50%. And they find this really, really an expression of the problem with anti-discrimination law, that there is no social justice in this concept of anti-discrimination law where everyone is treated equal, right? So if you affirm that women shouldn't have more than 50% of top leadership positions, I think you are enforcing a very formalistic and very mathematic concept of non-discrimination, of equality. We should look beyond that, because we cannot really think about having good leaders if good leaders can be only 50%, right? So we need to move beyond that. Now, your question was about where, what is called in the debate reverse discrimination. So it's when we have, for example, it happens very frequently. I have students coming to visit me and they don't even want to talk about that because they don't want to confess that they have, a white male student has been discriminated because they took a white female, because there were 2 posts open for that job in that specific office, and particularly in internships, and they usually take 1 man and 1 woman, and the man was already gone, and they prefer the woman to another very good man. So for how I see this issue, the female candidate is not exactly the same as the male candidate, because for how the system is conceived, the female candidate had to work more to reach that level of skills to access that post. So when, this is a recognition of white male privilege, which is something that is very difficult to recognize for us because, it questions our faith in the system, it questions our faith in how we take decisions. So it's a very complex conversation to have. But I think we need to have this conversation, because dismissing quotas as simply discriminatory doesn't make any sense. If you don't have quotas, African American will never access education, women will never access top leadership positions. That is the truth. And we shouldn't be afraid to say that. Now, we can look at anti-discrimination law to fight these and to say, like, okay, let's enforce quotas. But this is very difficult because courts have put limits to how you can enforce quotas, even in corporate settings in general. Or we can have another conversation, say, how can we be very much inclusive from the very beginning of the pipeline to reach top position. So until we reason about having just 50%, the glass ceiling is still there. It just moved a bit, but it's still there. We need to break the glass ceiling and to grant access to top leadership position to everyone who can be a good leader. And part of this being a good leader has to do with our experience with discrimination, with our sexual orientation, with our gender, okay? So we shouldn't even talk about colorblind or gender-blind leadership, but we should have a conversation that takes into account all these components.
Okay, thank you very much, Matteo. I think we are just at the right timing. Thank you for this really interesting conversation. I'm sure your research is going to give us more info about it, and I think it's something that is definitely under progress in our society. So looking forward to reading more from your articles and books. Thanks.
Thank you very much, and thank you to everyone. Take care and stay safe.
Thank you. Goodbye.
Bye-bye.